Hi, everybody. This is David O'Day with O'Day Schneider PLLC. And today we're talking about the Confrontation Clause, the right to face one's accuser in court, and its critical role in military domestic violence cases. At its core, the principle is simple. If the government wants to use someone's words against the accused, that person must appear in court, take an oath, and be subject to cross examination. But in practice, domestic violence cases often stretch that rule to its limits. These cases involve statements made early, sometimes in crisis, to law enforcement command or medical personnel when emotions are high and safety is perhaps uncertain. And later, the alleged victim may choose not to testify for a number of reasons. They may reconcile with the accused, fear retaliation, or simply want to not relive the experience in open court. When that happens, prosecutors cannot automatically introduce those earlier statements. Under the Confrontation Clause, if a statement is testimonial, that is made primarily to help investigate or prosecute a crime, it cannot generally be used unless the defense had a prior opportunity to cross examine the person who made that statement. This includes formal statements to investigators, sworn written accounts, or interviews conducted after the fact. But not all statements necessarily fall into that category. For example, a 911 call made during an ongoing emergency are usually considered non testimonial because their primary purpose is to get help and to not build a case. The same can go for some spontaneous statements made in the heat of a crisis or a remark made for medical treatment. By its design, the Confrontation Clause isn't about shielding the guilty, it's about ensuring that convictions rest on live, tested evidence, not on paperwork or secondhand accounts. In domestic violence cases, that's a difficult balance. Commanders can seek accountability, victims can seek safety, but the accused deserves fairness, and those standards are articulated in the Constitution. And the Confrontation Clause ensures that the system honors all three of these interests. At the end of the day, it safeguards not just the discipline, but the Constitution itself, making sure that when a conviction happens, it happens the right way, with evidence tested in open court, witnesses who can be questioned face to face, and justice that can withstand scrutiny. Thanks for watching the video.